Welcome, everybody. I'm Ruth Chambers, Senior Fellow at Green Alliance. We'll get going in a minute, but you're all very welcome. Just a few technical things to start. We're running this as a full Zoom meeting, so if you want to keep your camera on, you're very welcome. If you want to ask questions at the end, please raise your hand using the raise hand function. We're keeping the chat open as well, but maybe it's better just to have one big conversation as a group and perhaps use the chat to share any links or information. So I hope that sounds okay. We're expecting a few more people, but as we want to be prompt and finish at 2 p.m., I'll just kick off with a few opening remarks before handing over to my OEP colleagues. So welcome again from Green Alliance. We're absolutely delighted that you could join us today for this event, where we're going to be discussing the outcome of a really important legal case on environmental principles. I'm joined by two colleagues from the Office for Environmental Protection, or the OEP for short, and I'm sure you don't need reminding, but they are the statutory environmental watchdog in England and Northern Ireland. And the colleagues joining for the OEP are Kate Handy, Head of Litigation and Casework, and Elaine Webb, a Principal Lawyer. Before I hand over to them, though, I just wanted to set some brief context to remind you all why we're here today. And I wanted to take us back to the Environment Act, which many of you will remember was passed in 2021, and which sets up a new system of oversight and accountability to replace that which we lost when we left the EU. It's got four cornerstones. One is the OEP here today. The second is legally binding targets on nature, air, water and waste. The third is an environmental improvement plan, which the current UK government is revising. And the fourth is a set of 5 environmental principles and a linked policy statement with a legal duty to guide government policy making. Now, Green Alliance worked very hard with our partners, several of whom are attending today, I'm pleased to say, through the Greener UK coalition to secure that new governance system, and we've been making good use of it ever since it came into being. The duty on environmental principles is a really important part of that system. It's intended to ensure that environmental considerations are at the heart of government policy making and not treated as an afterthought. And the legal case we'll be discussing today was the first time that the courts were asked to consider how that duty to take the principles into account should work in practice. Because of this, there was a lot of interest in the case. And in a few minutes, the OEP will explain why it decided to intervene in this case, and it will also help us to understand the court's findings. But briefly, from Green Alliance's perspective, this was the first time in our 46-year history that we've ever been involved in litigation. We thought very carefully about that, of course, but our trustees decided that we should get involved because our involvement in helping shape the Environment Act meant we had useful evidence and expertise to assist the court's understanding of how that duty on environmental principles should be applied. But we also wanted to ensure that the court was aware of the strong public interest in the role that environmental principles play in policy making. So we'll now hear from Kate and then Elaine before moving to a Q&A. So please do save up your questions for that. And a final thing is that the event is being recorded, so will be available afterwards on the Green Alliance YouTube channel. I'll hand over to you, Kate, and thanks very much for joining us.
Thanks very much, Reese, and hi everyone. It's nice to see you all. So I'm going to just start with a little bit of a very high-level introduction to the OEP. I'm sure most of you know who we are, and we do have a few slides which hopefully will pop up in a moment. It's perfect. Yes, so as Ruth said, the OEP is one of the 4 cornerstones of the Environment Act, and therefore a key part of our role. Our mission is to protect and improve the environment by holding government and other public bodies to account. So you can see already, before we even get into any detail, that we would naturally have an interest in those other 3 cornerstones. We are partly here to ensure that those work as they should, and that government meets its own stated ambitions for the environment. So just as a bit of an introduction, if we could just pop to the next slide, the functions that the OEP has broadly split into four functions. So the first is that we can advise ministers regarding proposed changes to environmental law. We can also provide advice on other matters relating to the natural environment where we're asked to do so. So we can give advice of our own volition if it's in relation to a proposed change to environmental law, and we can give much broader advice if ministers ask us to do so. So a recent example of advice that we've given, which was of our own volition, was in relation to the planning and infrastructure bill that's currently going through Parliament. So that's just an example of what we've done with that function. The second function that we have is to scrutinise environmental law. So we have a duty to monitor the implementation of environmental law, and also then we can report on matters connected with the implementation of that law. So some examples of that we have done is we did a report into the Water Framework Directive regulations. We did one early on into environmental assessments, and then, as will be is relevant to this case, we also did a report earlier this year on the environmental principles policy statement, kind of looking at its early implementation, what was going well, what perhaps could be improved, and we made some recommendations. So that was obviously relevant in our decision to intervene in this case that we had to talk about. The third of our functions is to scrutinise the delivery of those long-term environmental targets that Ruth mentioned as one of the cornerstones, and also progress against the environmental improvement plan. So we are also very keenly awaiting the new revised EIP when it arrives, and we do an annual report on that. Our most recent one was published in January. And then the final set of functions that we have are our enforcement functions. And so we are able to receive complaints from members of the public and other organisations where there's a suspected failure by a public authority to comply with environmental law. Again, we can also launch those investigations kind of our own initiative if we have information, perhaps through our monitoring function, that indicates that there might be a failure. And it's in the context of that enforcement functions that we have a specific power, if we can just move to the next slide, please, to intervene in cases that are brought by third parties. So judicial or statutory review cases where they relate to a serious failure to comply with environmental law by a public authority. So that's the kind of parameters of it, that it must be about environmental law. We need to think it's serious, and it must be about an alleged failure by a public authority. But I think crucially, and this is quite important to us, and we think it's a useful thing in our toolkit, is that we can intervene in cases whether or not we think that failure happened. So we can look at cases, from either side, or actually the approach we've tended to take is to try and take a more neutral, impartial position. So I just thought, in terms of scene setting, it might be helpful to just talk through the kind of, how do we as the OEP decide whether we want to intervene in a case. As you can imagine, there's an awful lot of environmental law cases out there. We don't have the capacity to deal with or intervene in all of them, and I don't think that the courts would particularly like that either. So after we did our first intervention, we decided that it would be helpful to publish some guidance that's available on our website as to how will we decide whether to intervene. And I mean, a lot of these things are fairly obvious in many ways, but I think our key driver is there some additional strategic value that we can add to the case? So do we have a perspective that the other parties don't have? Obviously, as you would expect, when there are two parties to a case, they will have very specific reasons for bringing that case, which may be more specific to the facts than looking at what the correct law ought to be. So we will often look at, where do we think there needs to be clarification in the law? Where would it be useful to have kind of a wider set of principles around that law? do we have particular knowledge or expertise? For example, here, have we done a monitoring environmental law report? Have we done an implementation report that's looking at similar areas? Is there a particular issue of public importance that needs to be addressed? And then the other key fact, which was relevant here, is it the right time to intervene in terms of where the case is in its journey? So we say in our guidance that we would usually expect to make interventions at the appellate level, so the Court of Appeal or above, and that is what we've done so far. That's not to say that we wouldn't ever look at a case at the first instance in the High Court, but generally speaking, the kind of core legal issues that require clarity really come out in that appellate stage, and that's where we have considered, at least so far, that that's where we can add the most value. So if we just pop to the next slide, I'll just very, very briefly, this is just a list of the cases that we have intervened in so far. And I think, I've said this in other spaces, this is probably a higher number than we might have expected to do in the short time that we've been around. I would usually be expecting it would be a function that we use quite rarely for those reasons, in terms of making sure that we have that strategic impact and that we're there as a kind of authoritative, independent voice for the court and really to help the court. But as it happens, there have been 4 pretty major environmental law cases in the appellate courts over the last couple of years. So the first case we intervened in was Finch and Surrey County Council. That was in the Supreme Court. Haven't got time today to really talk about it in any detail. I suspect it is well known to most people on this call, but that was the first time we were able to go and sort of make our markers. This is what the OP wants to do, and the key point there was that we didn't, and this has continued with the other cases that we've intervened in. We didn't talk about the facts of the case. We focused very much on the law, what we thought the law ought to be, why we thought that the law ought to be interpreted in this particular way, and how we thought the court could develop some principles or interpretations that will be of wider application beyond the facts of that case. So we followed that same process. So Finch is obviously one that's been reported, a judgment's been handed down. The Pickering Fishery Association case was also related to the Water Framework Directive regulations, which we had done a report on, an implementation report on. So you can see where these connections are that we're looking for. And that case, again, was we went and said, this is what we think that the law ought to be. And that judgment was handed down in earlier this year. Then we obviously have the case that we're going to talk about now, which I'll hand over to Elaine in a moment. And then the other one that we intervened in was case of Fry and Somerset Council, which was in the Supreme Court in February this year. We are awaiting the judgment on that. But yeah, I just thought it would be helpful to give a bit of a flavour, set the scene for the kind of things that we take into account, and the other approach that we've taken, which hopefully will be of interest to people on this call, is that we publish our submissions in full on our website, and we've done that with all 4. They're all available if you want to see what we said to the court and what we were proposing was the right approach. And again, that approach is quite important to us, that we are transparent, and then we hope that although we would not be able to or necessarily want to intervene in every single environmental law case that raises these issues, at least other parties may be able to look and say, well, this is what the OEP thought or said about this particular issue in another case. So that is open and available for people to use. So I think in terms of scene setting, I'll stop there and I will hand over to Elaine, and then very happy to answer any questions when it comes to it. Thank you.
Thanks very much, Kate and Ruth. Could we have the next slide, please? Just a comment on something that Ruth said. Although it was the first time the Green Alliance had intervened and been involved in court proceedings, we were very, very pleased that they were, because there were a few points where we were able to really support one another in relation to the procedure and a few challenges we had with the administration. So thanks again, Ruth, for your support on a few tricky things that came up in the course of it in the early stages. So I apologise for this very dense looking slide, But this was really the problem with the RCA case in some ways. The facts were rather complicated. And so if we'd had a choice, this probably wouldn't have been the first case in which we would have liked to intervene, or indeed the first case we would have liked the court to be looking at the duty. Anyway, this is what we had. So I'll try to just whiz through this quickly, but I hope this might be a useful sort of aid memoir later if you're looking back at this or looking at the judgment. So Rights Community Action challenged a policy which had been set by DLUC, as they then were, Department for Levelling Up Housing and Community. So I'm going to keep calling them that because that's who they were at the time when this policy was made. So the policy related to the power of local planning authorities to set building efficiency standards for new buildings, which were higher than building regulations. And that's a power that they had under the Planning and Energy Act 2008. In 2023, DLUC made a written ministerial statement about this, the way this power should be used. And that statement was not accompanied by an environmental principles policy assessment. But in October 2023, there had been an EPPS assessment in relation to the draft of that written ministerial statement, which had been approved by Minister Rowley. Now, the sharp-eyed members of the audience here will be thinking immediately that the duty hadn't even come into force in October 2023, and that's right. It came into force on the 1st of November 2023. But of course, from the date when the Environmental Principles Policy Statement was published, there was nothing to stop government departments deciding to apply it, and that's what happened here. So it was applied voluntarily in October 2023, a month before it really had to be. So far, so good, except that having seen the draft and the EPPS assessment, Minister Rowley was then moved on to other duties. Baroness Penn took over and she approved the written ministerial statement, but she hadn't seen the EPPS assessment. So they're a bit like the figures coming in and out of the weather house and either seeing the statement or not. And then Rights Community Action challenged the written ministerial statement on various grounds, including the failure to comply with Section 19 of the Environment Act by doing an environmental principles policy statement. And interestingly, one reaction of DLUC to this was that in February 2024, they did an EPPS assessment and they provided that to Baroness Penn and asked her whether she thought that the written ministerial statement, which had been made in December, needed to be amended. She said it didn't, but then she wasn't actually available. And Minister Rowley came back out of his door in the weather house, as it were, and he considered it and confirmed that it should remain as it was published. So I hope that's reasonably clear. So one point of which was odd was that the changing of the ministers, but that didn't really matter. There was a thing about the dates, but that didn't really matter. But other things that I just mentioned because they're perhaps interesting in the context is that this case also threw up a sort of tussle between the power of central government and local government. That was the thing really that RCA didn't like, the fact that local planning authorities were being constrained in setting higher energy efficiency standards in order to reduce carbon emissions from new builds. Another thing is that this case is an example of an environmental policy being sort of traded off against another policy, in this case, a housing policy. Because what came out in the facts was that the reason the government wasn't so keen on local authorities going further was that they thought that this might create a difficult environment for house builders who would rather know exactly where they were and that they just had to comply with the building regulations, and that this could have an unfortunate effect on the housing market and reduce available housing. So I'm sure these aspects will come up in future cases, but just to note that they were part of the scene here. Next slide, please. Thank you. So RCA's first round of went to the High Court, of course, complaining that the Secretary of State hadn't complied with Section 19. There were also grounds relating to planning law and the Planning and Energy Act, but the OEP was only interested in the first ground, the Section 19 ground. And the Secretary of State argued in the High Court that the failure to comply with Section 19 when the policy was made in December had been remedied when an EPPS was prepared and considered in February 2024. And that was the step that was taken in response to the legal challenge. RCA had argued that there were quite a few things wrong, really. One was that the EPPS, which had been done, failed to address properly the environmental effects of the change of policy that was being announced by the written ministerial statement. They also complained that it was giving too much weight to a future policy, the future homes policy. And they also complained that anyway, there hadn't been enough consideration of actually the environmental effect of the policy overall. The judgment was quite short, but the Mrs. Justice Leven agreed with the argument for the Secretary of State, and she found that the February assessment had been done in substance with rigour and an open mind, applying a test established in a case called HOTAC, which is a case in relation to the public sector equality duty. So the ground one challenge was rejected, and in fact the other grounds of challenge were rejected as well. As I say, the judgment was quite short and delivered quite quickly, and didn't make much reference really to the actual wording of the environmental principles policy statement. But of course, that wasn't the end of the matter. So next slide, please. And the next thing that happened was that RCA appealed to the Court of Appeal on the grounds that the judge's interpretation of Section 19 and of the Planning and Energy Act 2008 were incorrect. And as you've heard already from Ruth and Kate, the OEP and Green Alliance were both given permission to intervene on that point about Section 19. Our submissions went into some detail about the context and the purpose of Section 19 and the Environmental Principles Policy Statement. And as well as that, we suggested that the court might consider setting out some general principles for applying the Section 19 duty. Because what we'd noticed in the decision at first instance was that the judge was quite welcomed the suggestion by counsel for the Secretary of State that it was a good idea to look at a lot of case law relating to the public sector equality duty and to apply a lot of principles that have been established in that case law over to this duty. And we were concerned that, in fact, the only thing really that the two duties have in common is that they both use the words have due regard, whereas the context and the effects that the policies might have and the purpose of the two duties is really quite different. But also, we didn't agree with the High Court judge's finding that the failure to comply with Section 19 in December 2023, when the written ministerial statement was made, could be remedied by the February 2024 assessment. We didn't actually mind what the outcome was. We were neutral on that. Our interest was in seeing the correct interpretation of Section 19, particularly, as Ruth has said, because this was the first case where the court ever had to look at Section 19. Could we have the next slide, please? Thank you. The Court of Appeal actually came to the same decision as the High Court judge, which was that they unanimously dismissed the appeal on both the grounds. The Court of Appeal decided that the February assessment did meet the Section 19 duty, and they said that it was appropriate and proportionate to the issues raised by the 2023 written ministerial statement, the environmental effects involved, and the environmental principles engaged. Two things that were really key, and we were very happy to see in the judgment, were that the Court of Appeal clarified that the Section 19 duty applies throughout the policy-making process, including when a policy is adopted. and that an assessment at a later stage doesn't cure an earlier breach. Now, if I could go into a little bit more detail into the points in that bullet point, there's a definition in section 47 of the Environment Act, which is that making policy includes developing, adopting, or revising policy. And it seemed that the judge at first instance was treating those as alternatives and perhaps saying that applying the EPPS at any one of those stages would be enough. So, for example, if the policy was going to be adopted or revised, you could do your EPPS then. And we didn't really agree with that interpretation. We felt that the definition saying it includes those things, those are points at which it should be done, and possibly even at other points as well. And so we were very happy that the Court of Appeal clarified that it does apply when the policy is adopted. And also on this other point, that by doing an assessment later, that doesn't cure a failure to do an assessment earlier. So the Court of Appeal were very clear that there was a breach at the time when the policy was announced without there being an assessment, but that nevertheless, there was nothing to say that the Secretary of State couldn't consider afresh later whether to approve a policy, having had due regard to the EPPS. The Court of Appeal went into a lot of depth in their judgment in describing the differences to the policy and the differences in the way the policy was looked at through the EPPS lens in the first time that was done in October, and then when it was done again in February. And they decided overall that what had been done was proportionate because the changes were actually quite small. And they discussed matters such as whether it was enough that two principles were mentioned, the integration and the prevention principle. And they decided overall that what the Secretary of State had done was sufficient to comply with the duty to have due regard, and that also that had been a proportionate approach to take. And they also took into account the fact that the policy is an interim policy, and the plan, Deluxe plan, was that quite soon in the future Home Standard would come along, and the policy announced in the written ministerial statement would be overtaken by the new policy. So we were very happy to have all that clarified, and therefore the court came to the conclusion that the later assessment couldn't be described as merely a rearguard action. It was more than that. It was an assessment which also satisfied the duty. Next slide, please. Thank you. So, as I mentioned, we welcome the court's clarification on those three key things, which is when does a duty apply during the policy-making process, what it requires, and that a failure to comply can't be rectified by a later assessment. Of course, we weren't at all surprised that in terms of what the duty requires, the Court of Appeal said pretty much the same thing as the High Court judge, which is that it's not for the courts to substitute their view on the merits for that of the decision maker. That unless the decision is actually irrational, that's a matter of judgment for the decision maker, how much weight to give to different aspects, and also to decide which of the 5 principles are the ones that are most appropriate and should be applied. The bit where we were perhaps a bit disappointed was that the court declined to lay down more general principles. That was our point about, well, wouldn't it be a good idea to establish some general principles that would apply to the complying with Section 19, rather than bringing over wholesale all the principles from the cases relating to the public sector equality duty. But although the court declined to do that in this case, they did indicate that this might be appropriate in a future case. And as Kate has already mentioned, we always publish our submissions on our website, and we've done that here. And so they might be of assistance in a future challenge to a case on the ground of failure to comply with Section 19, not necessarily a future challenge by us, but perhaps by somebody else. So that's really a sort of whistle-stop look at the judgment, which is quite long and very, very interesting. And I definitely think it's worth a read. And I'm sure some more aspects will come out in the discussion and the questions. So thank you very much. And I will hand back over to Ruth for the next part of the webinar. Thank you.
Thanks, Elaine, for talking us through. As you say, it's a long judgment with lots of twists and turns, but you did that really clearly and really brilliantly. And thanks to you, Kate, for explaining why and when the OEP chooses to intervene. I mean, I'm maybe not surprised that you've done, I say so many, it is only four in, what is it, four or so years, because the courts have generally, especially since Brexit, been more active on environmental law. So in a way, it's not surprising, but I do understand what you mean, of course. So we can open the floor now for any questions or comments that colleagues on the call want to share. Feel free to put your camera on. And if you want to ask a question, if you can raise your hand. If you're struggling to find the button because it's not obvious, if you click on the little heart at the bottom, which says react, and then you can find the raise hand function in there. I appreciate it's a little bit hidden. Or you can just wave if that's easier. And if your camera's on, then I will see you. So does anyone want to ask any questions or share any thoughts about the judgment? Otherwise, I can get the ball rolling while we're thinking. Rosie, do you want to go first? And please introduce yourself as well to the meeting. Thanks.
Thank you. Yeah, Rosie Sutherland, I'm Head of Environmental Law at the RSPB. Just huge thanks both for this webinar, possibly slightly more importantly for being able to intervene. I think it's absolutely brilliant that both Green Alliance and the OEP did that, and also the other interventions that the OEP has done. Will you please forgive me? I haven't read every paragraph of the judgment, so apologies if this is already set out in there, but I was just reflecting that the kind of second time of asking or second time of doing within the ministerial reasons for, yes, we've complied with the duty, and here's a little bit of a reasons why we haven't changed anything. I just wonder whether that helped to enable the Court of Appeal to reach its conclusions on that point, because as many of you know, part of our concern is that evidence of how the duty is being complied with. And although the principal's policy statement does give some direction and some guidance, it's gathering evidence of how each minister does that. And I can't help but think that if it had been applied earlier in the process, could it have made a difference? And then my main point, which is, but then coming up with the evidence to show that that might have been the case. I mean, that is going to be incredibly tricky, isn't it? Was that discussed at all here, that if the duty had been taken, I'm going to be rude and say properly, at the earlier stages, it could have made a difference?
Thanks, Rosie. Do you want to pick that one up, Elaine?
Yes, sure. Really interesting question, Rosie. There wasn't really discussion of that. I think partly because of the fact that this policy would have started in development before the duty came into effect. So this probably we won't have another case in this situation because the duty has now been in effect since the 1st of November. So it wasn't, but I totally agree with the point you're making that unless, let's assume that it's in a situation where the policy starts to be developed when the duty is already in place, that if it's not considered right at the beginning, some policy options might be rejected then that shouldn't have been. If I'm sure that's what you're getting at. So it wasn't really, that wasn't gone into here. But the other thing that I think you mentioned right at the start is that the Court of Appeal did take into account what they described in paragraph 99 as the relatively narrow scope of the issue. And so that was another reason why the court said we can take that into account in deciding what they did was proportionate. And also bearing in mind, we're not going to we're not exercising the discretion. To show that the discretion has been exercised is a fairly low bar in a legal challenge. So I could go on, but I think I won't, if that's clear enough.
Thanks, Elaine, and maybe just also to add another point in relation to Rosie's question. So it's not one for the court case or the court judgment, but of course, when all of this was happening, we were in what the government termed an implementation period for the duty, because the environmental principles policy statement, which the duty applies to, had been delayed in being published, and eventually it came out, and then it came out with an implementation period attached, and that was in this time. So I think an interesting question for government colleagues, not now on this duty, because it's thinking perhaps in the past, but when important new responsibilities are going live and they are in some kind of a holding pattern or an implementation duty, what should be happening in that time to help government get ready? Because clearly, what we might think should have been happening, which was preparedness and maybe doing draft statements and that sort of thing, wasn't happening in this case. So one for the future. Mike, you've got your hand up. If you'd like to ask your question and introduce yourself, please.
Good afternoon. Yes, Mike Trejan. I work for the Environment Agency, but please treat this as a personal question. Um, I'm thinking about things in relation to, say, the circular economy, um, because it feels to me that those principles are exactly what we need, but how they're applied in terms of, how should we say, existing regulation and policy towards regulation going forward feels quite complex to me because, for example, we tend to regulate in silos. So, for example, we regulate, waste and resource at the EA along with other emissions and stuff. So there's a degree of integration, but it's not integration along a systems based approach, if you like. So, for example, in the terms of the circular economy, if you were looking at that level of integration, polluter pays as well, then you would be looking at product design, which we don't have any control over, for example. So you're looking at a completely different way of integrating regulation, which would be great, don't get me wrong. Something I'd be very much in favour of. But I guess my question is, how do we get from where we are now, given the huge amount of both history in terms of the companies, what they've invested in, what they do, and case law? How do we get from there to this sort of more fully integrated way of regulating?
Thanks, Mike. Some good questions. I mean, a couple of thoughts from me, and then Elaine or Kate. Maybe Elaine, you'd like to come back on this one. Great that you've asked a question. Obviously, not on behalf of the EA, but with an EA sort of mindset, perhaps, because of course the EA, Environment Agency, and Natural England are a little bit betwixt and between on this duty, in that it applies to you when you're making policy on behalf of ministers, but you don't do that very often. So mostly you're kind of observing the duty in practice rather than necessarily having to legally comply with it. We know, don't we, that the government is busy working with the Circular Economy Task Force to prepare a new circular economy strategy. So how the duty should apply to inform the policies within that strategy is a pretty live question, isn't it? But Elaine, and any words of advice for Mike from a circular economy perspective?
Thanks, Ruth and Mike, for a really interesting question. Well, yes, as Ruth says, the Circular Economy Task Force, I think, are meant to be reporting in autumn. And if the government was then to adopt a different circular economy policy, they should apply the EPPS to that. But you mentioned the fact that about regulation. Of course, the problem is the EPPS unfortunately doesn't apply to regulation. It just applies to new policy or adoption or revision of policy, which is probably at a higher, level up here somewhere than the regulation. So we do have this slightly funny situation, though, that, as I'm sure you know from your work with the EA far better than I do, some regulatory regimes have the precautionary approach expressly included within them and mentioned. That's great if they do. But if they don't, then the principles don't necessarily apply. I mean, there's nothing to stop them, there's nothing to stop in a way them sometimes being applied while decisions are being made, but they wouldn't legally apply under section 19. So you're right, it's not integrated, it's all a bit piecemeal. I don't know if you want to add anything there, Kate, or if I've really properly answered your question, Mike.
I would just add, I mean, I agree with what's been said. I think when one of the things that we were doing when we did our report, one of our recommendations, which kind of goes to Rosie's point earlier as well, is around the importance of transparency. So again, while there's no requirement to publish these EPPS assessments, we recommended that was done routinely. And I think if that happened, then Mike, to your point, you'd be able to start to see how it was being taken into account in that development. So that, because I think from our perspective at the OEP, that's really the key, is to be able to kind of understand what it is to apply the EPPS duty, not just legally, if you think of the legal bar is here, but actually well, in order to really make sure that those policies that are created do genuinely take into account those principles to make better policy. And I think that's something that we're very keen to make sure that we keep saying, is this is not a sort of tick box exercise or another onerous duty that's not for anything. It is, exactly to your point, Mike, the purpose is to try to make better policy. And I think particularly it'd be interesting to see from our perspective how it's applied outside of the core environmental sphere, because I think that's an area where it really ought to have quite a significant added value, is for those policy areas which maybe are not core environmental in and of themselves, but how can environmental considerations be taken into account? But I think to come back to the point, I think that transparency is really key. So if we could start to see some of these assessments and how they've been done, then it'd be much easier for others, whether that's the OEP, ENGOs, regulators, to see what works well and maybe what could be improved.
Thanks,
Great.
Kate. And on that, I'll just move us on, Mike, if that's okay. And on
Thank
that
you.
transparency point, it is really important because there's a genuine public interest in understanding how this duty works. It's not that any of us are trying to trip up government policy makers or, looking for a legal challenge hook or anything like that. We really want to, well, A, be reassured that the principles are informing policy in a proper way, and B, just understand how that process is working. But Victoria, you probably want to come in on this point, given your work at the OEP on principles. So I'll bring you in now.
Thanks. It's actually going to be Ellie Strike that's speaking from my account. So here you go, Ellie.
Hi, sorry, I snuck in. And firstly, hello, Mike. Nice to see your face. We used to work together at the Environment Agency some long time ago. But yeah, just to add to the points that Elaine and Kate have already made, we obviously sort of draw on this point about transparency, and coming back on that, there are opportunities, we think, around the policy making cycle where that transparency really could be brought more to the fore, and that does include things like post-implementation review of regulation. So there is an opportunity there in the kind of regulatory framework. Some of the recommendations we made were around ensuring that the EPPS is considered in post-implementation review, that therefore it's embedded within things like the templates and documents and guidance that are used at those various points around the policy making cycle. So there are very definitely opportunities there, and I think that's one of the things that we will continue to press home is, let's see how the EPPS has been applied, and that will assist us in undertaking our scrutiny role, but also everybody else who's involved in that scrutiny process as well. That was what I wanted to add. Thank you, Ruth.
Thanks, Ellie, and thanks for all of the work that you do at the OEP in monitoring the duty, obviously, and we'll start to wind up and look ahead to the future and what the next few months might have in store for the duty. But one thing I wanted to mention is, as well as the OEP's report, and Green Lines did its own analysis as well, DEFRA is doing a review of the high-level implementation of this duty across government. I think that is due to be published later this year. So that will also be an important document to help us all understand how the duty is bedding down and where early lessons might be learned. But Anusha, over to you, please, for your question.
Thank you very much, Ruth. And I'm Anusha Shah, I'm Global Senior Director for Climate, Water, Nature for Arcadis. Firstly, well done. Congratulations. It's really good to see how OEP and Green Alliance has really worked well. I was just reading the judgment on the side whilst we were talking. I think my question is very much what the discussion is about the implementation of some of these regulations. And is there a way, or there is a talk where ultimately we all want to do the right thing, whether it's government, the NGOs and all, but sometimes we get embroiled in a lot of legal words and interpretation of those words, to implement it and have that whole public come on board on all the things. Is there some work being done to kind of almost like a dummy's guide to some of these regulations and making it more accessible and in a language which is, I think Environment Agency has easy English, or I remember doing a training on that. So, but having these legal documents translated as much as we can, it's not always possible, so that there's absolute clarity, and because the intentions are right, it's just getting the clarity on these things. Can we do a communications piece on regulations, is what I'm getting at.
Yeah, I mean, it's a great question, and I'm sure OEP colleagues will have a view on that. I mean, just to kick that off, then in relation to this duty on environmental principles, DEFRA is like the sort of the owner of it across government. Obviously, it applies to all of government, but they're responsible for making sure that their colleagues elsewhere understand the duty and pay due regard to it. And they have done a lot of work. They have a dedicated team in DEFRA that work on environmental principles. They've published things like an explainer video, which is, quite high level and friendly, if you like, a template to guide policymakers. So step by step, this is what you do to make sure that you're taking account of principles when you develop your policy, and also a toolkit with various resources. None of that is published, so we aren't able to say, well, gosh, yes, it's written in the right accessible language, or it could be improved, or that sort of thing. But we know that it does exist, and it's available on various kind of civil service learning platforms. So there is information on the duty, but it's not accessible to the wider public, unfortunately.
But is there a plan too? Because then, at least wider public should understand what the legal, what they can and can't do. Then I think everyone benefits in the long term. So, it's just because otherwise, what's the point of regulations when public are not there for whom the regulations ultimately are meant to be?
Definite support from the room on that. Kate or Elaine, any thoughts on wider public accessibility of these important regulatory and legal duties?
Could I just say really briefly, a great question. We try to write our reports in accessible language that can be understood by anybody, but obviously that's a drop in the ocean, really. It's not a program. When we work on something and we communicate to the public, we try to do that clearly via our website and our reports, but it's not something we have an overall work stream on. Any more on that, Kate?
Thank you, Elaine. Sorry, before we go to Nigel, I think my thought was triggered by, I was on a completely different forum. We were trying to get nature embedded somewhere, and one of the lawyers actually told me, and when I was kind of saying, how do we make sure that there's clarity? And that person actually said, no, it's been kept ambiguous for a reason. So there is room for changing later on. And my worry is that this ambiguity can be such a problem when we have such a short time to make some decisions on things that matter, that are important for our very survival on this earth. So are we going to spend rest of our time really kind of clarifying the ambiguity, or should we be clarifying? So I think I don't know how lawyers work. For me as an engineer, I'm just thinking clarity on things. This needs to be done, or this is the complex thing. Then we find a solution to those complex things, right? So is there a tiff between the way lawyers form it, and is there a time for almost like a movement to get more clarity than ambiguity in clauses, is what I'm trying to get at.
Really,
Nigel might have a good reply to this.
Yeah, good points, Anusha. We'll move on to Nigel, but I think it's probably not the OEP's job to do any of that. To be fair to them, you make some really good points. We can certainly pick those up with Defra and other colleagues. But Nigel, do you want to ask your question? And then we'll just finish maybe with a look ahead to what next for environmental principles across the UK. But over to you. Thanks, Anusha.
Yeah, thank you.
Just like clarity on the word regulation, which we've been talking about. A statutory instrument are called regulations, but they're legislation. My question really is an authorization or license to discharge to water or to operate an industrial plant or landfill site, is that regulation? Is that what we're talking about?
So when we're talking about the duty, it applies to all policy making, and that includes proposals for legislation. But Elaine, do you want to add some legal detail on that?
But it doesn't include what are being called administrative decisions, such as making a decision on an individual license application.
It's legislation.
Primary and or secondary. So that is within the scope of the duty, as is all policy. But as you know, Nigel, from the Environment Act, there are some carve-outs for things like defence policy and fiscal policy. But nevertheless, it's quite a broad scope.
But a policy statement is not regulation. A white paper saying the government believes this, which is clearly policy, is that regulation?
So the policy statement on environmental principles is just what it says. It's a policy statement. It's a statutory document because it's required to be produced by the Environment Act, but it's not a regulation. It's the place where government sets out how the principles should be taken into account in the policy making process.
No, my question is to what kind of regulation does the principles apply?
It applies to policy. So if a white paper was proposing a new policy, then we think that the environmental principles policy statement should have been applied to the development of that policy.
See, I wouldn't call that regulation. I would call that a policy statement.
I don't think we might not call it regulation either, actually. I mean, there have been questions about regulation, but that's not the terminology that's used in the in the statute or in the EPPS.
Thanks, Nigel. Are there any final questions before we just look ahead to what next on environmental principles? So I'll just kick this final part of the meeting off, and then Kate and or Elaine, if you've got any thoughts on what next, or Ellie again via the meeting, then that would be really, really welcome. So looking ahead to England, we've got this DEFRA report coming out later this year, and then next year in England, there is going to be a review of how well the Environment Act has been working, and that we hope will include an assessment of this duty, because while we can only work with the duty as it's currently framed, I think many of us would feel that there are probably opportunities to helpfully improve it. In Northern Ireland, I think we're waiting for that first environmental principles policy statement to be published. So we don't have it yet. I know that the OEP and stakeholders are really keen to see that. So let's all hope that that comes forward at the earliest opportunity. In Scotland, the system there started around about the same time as the English system. It is a little bit different. It seems to be moving forward reasonably well, but if anyone feels differently, then shout now or hold your peace. And then finally in Wales, the last country to develop a new system of environmental governance, but progress is on the horizon. There is a bill that's before the Welsh Parliament, Senedd Cymru, that we hope will pass next year, and that includes a section on environmental principles with a duty not just on Welsh ministers, but on Natural Resources Wales, the environmental regulator in Wales. And it's framed in a slightly different way to the duty that applies in England and Northern Ireland. It's probably a little bit stronger overall, so let's hope that it stays so. And we hope that that duty will start to inform Welsh policy from 2027. So there's a little potted summary of what's next on the horizon. But Kate, maybe I'll come to you first for any final words on the principles horizon from the OEP, and then finish with you, Elaine, and then we'll wrap up for the day.
Thank you. Yeah, thanks, Ruth. I mean, I might ask Ellie to jump in as well if she has anything to add. But it's an active, following our we did our report, and obviously we have the response from government, but then we will always be monitoring to see what is happening. And we're currently thinking about, how do we continue with the monitoring of the implementation of the EPPS. And obviously one of our key recommendations was that, which I think they are doing, as you say, DEFRA is doing, is to evaluate themselves the impact of the duty, and that should be ongoing. So not a kind of like do it once and it's done, but a kind of ongoing look at what works well, so that over time best practice can be developed. But as far as the OEP's kind of specific role in that space, that's something that we're actively talking about and thinking about now. And I don't know whether, Ellie, you have anything to add on that specifically at this point, or if it's enough to say that for now.
Hi, Ellie. Do you want to come in? Hi.
Yeah, I was going to try and actually appear in person.
We can see you.
Can you? Great.
Yep.
So I don't really have a huge amount more to add than Kate has already said. Obviously, we published our report, which was the kind of early days review of implementation, but that isn't an end to the OEP's interest in the EPPS implementation at all. We are now actively kind of thinking about what our ongoing approach to scrutinising application and implementation of the duty will look like. I suspect that will have a couple of elements to it. One which might be more tactical in terms of looking at how the duty is applied across individual policy decisions, versus a slightly more sort of strategic approach in terms of building our evidence base and understanding what that looks like on a more sort of systemic level. But we are working that through internally first, and then I suspect we'll be having some conversations with external folk to whom it's relevant as well before we really start embedding that. But it won't be the last you hear of EPPS from the OEP. Certainly, I think you will see that, certainly when there are matters that the OEP is interested in, we will always ensure that we're kind of looking at that through an EPPS lens, as well as any other lenses that the OEP might be looking at something through. So it won't be the end of the conversation here. So watch this space and we will update more, hopefully in fairly short order. Thanks, Ruth.
Thanks, Ellie. That's really helpful. And just as a final word from Green Alliance, then obviously Green Alliance with its partners, such as the RSPB, WWF, Friends of the Earth, Client Earth, and others, is also actively monitoring how this duty is working, not just in England, but across the UK. It is an important duty. There are ways in which its implementation can definitely be improved. And by holding discussions like this, hopefully we can continue to learn from each other. So I'll finish by saying a huge thanks to Kate and Elaine for joining us today, for sharing their insights and their commentary on this really important case. And also a huge thank you to all of you for joining, spending your lunch hour thinking and talking about environmental principles. We hope to see you soon. We'll draw this to a close and we hope that you have a good rest of the day. Thanks very much.